legally specific to Jamaica. It's principles that apply across the board, not just in Jamaica, Trinidad, Barbados, as well as overseas. I know the US system is slightly different, but the principles are the same. So it is going to be relevant to everybody wherever they're located or wherever they reside. Okay, still going through the introductions. We're in Division 25. If there's nobody else for Division 25, going once, going twice.
Good evening. I'm Director David from Kiwanis Club of Montego Bay. I'm with Director Designate Crystal and expecting others to join. Thanks for the invitation. Have an enjoyable meeting. I will learn something again.
Yes. Okay. Welcome, Director David and Director Crystal. Welcome again. We're glad to have you here. Always, Montego Bay is one of our biggest supporters. So we're moving from Division 25.
Good evening.
Good
evening.
Good evening.
This is immediate past president Indira from the Kiwanis Club of Negril Point. We have three of us online and happy to be here. Hope we will have a good meeting. Thank you.
Thank you. Thank you. And welcome to you and your delegation all the way from Negril. I hope you've got back light. You know, I heard that Negril was having some challenges.
Some places have and some places still don't have. They actually blocked part of the road this morning and then they did again this evening because they still don't have any electricity. But we're good otherwise. Thanks.
Okay, that's good to hear. That's good to hear. All right, we're in Division 23 West. Kiwanian clubs from 23 West.
Hi, good evening. Good evening, fellow Kiwanians and guests. Greetings.
Greetings.
This is DLG Pauline from the Kiwanis Club of South St. Catherine, bringing you greetings. Currently, there are three of us online. We expect others to join, and we're very happy for this opportunity to be here. Thanks so much.
Thank you. Thank you, DLG Pauline. We're still asking for Kiwanian clubs from 23 West. We're going to move now to 23 East. All the club members from 23 East. Kiwanians from 23 East. If not, let's move to 23 Central.
Good night, everyone. My name is Nakisha Irvin. I'm from Division 23 Central, Club of Nations Builders, sorry.
Yes. Welcome, Kiwanis Club of Nation Builders. I'm glad to have you. Is it just one in your delegation, Nakisha?
Well, it's just me now, so I hope others will come on soon.
Okay, make sure that they put their names in the chat so we can see them and recognize them.
Okay.
Okay, thank you. 23 Central, come on, let's hear all the people. I think I see
evening.
you, Kingston.
President-designate Stephen. This is President-designate Claudine Heaven from the Kiwanis Club of West St. Andrew. It is such a privilege to be sharing your meeting this evening. Yes. We are pleased that we have 9 members of our club joining the meeting this evening.
Nice.
And we really look forward to sharing the information that you have, your guest speaker will be delivering. It is a really interesting and timely topic. So best regards to all of you.
Thank you. Thank you, PD Claudine. And I hope you enjoyed the recent CLE training.
Without a doubt. Without a doubt, Stephen.
That's good. Thank you. And I'm glad to have you and such a large delegation coming out to support. We appreciate it. We appreciate it.
As always, we look forward to your support as well.
Yes, likewise. We will try and return the favor in our interclubs very, very soon. All right, so we're quickly going down the roll call because I want to get to the main attraction, which everybody wants to see. I think I saw New Kingston. Is there anybody else here from 23 Central or East? Please introduce yourself and your delegation.
Good evening, everyone. This is...
Go ahead.
Okay, this is President Pancita Kiwanis Club of Trafalgar. 2 of us on this evening. So happy to be here and hoping to learn more. All right, thanks for the invite.
Yes, thank you, DPD.
Stephen?
Yes, I'm hearing you, Kermit. Go ahead.
Stephen?
Yes, I'm hearing you, Kermit, but your signal is breaking up. So you're not hearing
Thank you,
yourself
PD
clearly.
Stephen. Good evening to
Yes.
everyone. I'm riding
Good
solo
evening.
so far, as far as I'm aware, Kiwanis Club of Downtown Kingston. But I'm here. Greetings to everyone. That's correct.
Greetings to you.
Oh, I'm just saying.
That's DP Kermit from Kiwanis Club of Kingston. I think his signal is intermittent, so that's why he's been breaking up. But welcome to you, Kermit. And
He's downtown Kingston. And
downtown
PD, it is great to join your meeting. I was hoping somebody else would bring you greetings from the Kiwanis Club of New Kingston, but I'm not sure they're accustomed to have me. I'm not going to do it all the time because you all are tired of hearing me. Anyway, it's great to join your meeting, and I'm sure we're going to have a lot of interesting comments and ideas, but there, I think, either 5 or 6 of us on, including Vice Governor Designate Sharon Diana. So this is DLG Gerthlin. Great to have be on.
Welcome DLG Gerthlin, and welcome VG Sharon. Welcome to both of you, as well as all of New Kingston. Happy to have you here as usual, and hope that you enjoy our meeting this evening.
Thank you very much.
Indeed.
Hi,
indeed.
Good evening, everyone.
evening.
DP Zoya Salmon Powell from the Kiwanis Club of Cyber Connect Jamaica. I know we have our dual member DLG Willie on, and we may have some more members joining later.
Okay. DP
Thank
Zoya,
you for having
thank
us.
you. Yes, indeed. Thank you, and welcome to the dual member DLG Willie, wearing multiple hats this evening. Long time no see. All right, ladies and gentlemen, winding up the introductions, and is there any other person, any other club that has not had an opportunity to welcome themselves? Any other guest of Kiwanians? This is your final opportunity for us to see and recognize you. I think I see Secretary Donald, East Kingston. Go ahead, Donald, you're on the floor.
Thank you, PD Stephen. Secretary Donald, Kiwanis Club of Eastern Kingston and Port Royal. I think there are 4 of us online at this time, and more will join in, I'm sure. A pleasure to be a part of your meeting. I hope to be informed this evening. Thank you.
Okay, thank you. And President Pancita, we see your message from Trafalgar. Welcome to other members of your club who are joining us. All right, ladies and gentlemen. Okay, got in right at the wire. Good evening.
Good evening.
President
This is
Josh,
President. Yes.
Sure.
Thank you. Thank you. This is President Josh. Good evening, fellow Kiwanians and guests. This is President Josh from the Kiwanis Club of Charlton, Alexandria. Thank you. Thank you for the invite. I'm happy to be here. I do see I have my PD Ashana Leng on. I'm expecting my secretary and a couple of others. So we're looking forward to an informative evening.
Yes, yes, indeed. Welcome, President Josh. And PD Ashana did send greetings also early on, but we don't mind it twice.
Wonderful. Okay, I just got in, so.
Yeah, so nice you got it twice. So it's
fabulous.
Okay.
Well, it's KCCA. Come on now.
There you go. There you go. There you go. All right, ladies and gentlemen, any other greetings going once? Now is the time, going twice. If not, thank you, everybody. Looking forward to an interesting meeting. I will just transition into apologies. As I mentioned at the top, some of you may not have heard, President Newton from our club has extended his apologies. He's unable to attend, so I'm sitting in for President Newton at this time. I'll just take the opportunity now to ask if there is any, DLG Willie, if there's any other apologies tendered from Kingston, and from President Dr. Eurydice, if there's any apologies from 23 Surrey Online.
PD Stephen, I have not received any.
Okay.
But we know that Treasurer Orville is off the island eating Grand Cayman.
Yeah, yes. So apologies for this, Treasurer Orville. President Eurydice, any apologies from your club?
No, not at this time. Thank you.
Okay. All right. Quickly, I'm going to go through the birthdays for this week. And also if anybody else who is celebrating a birthday or anniversary. So that would be for the week of July 16th to the 22nd, we have 4 Kiwanians from Kingston who are celebrating special birthdays. Minerva, who is the wife of Kiwanian Hamlin Pagan, she celebrates her birthday on the 18th. On the 19th, Treasurer Orville Lewis, who we heard apologies for, he has his birthday. So that's Minerva on the 18th and Orville on the 19th. Then we have past Chairman Lowell Mason and Loretta, his wife, have their wedding anniversary on the 19th of this month. And finally, Kiwanian Joshua Brown, tomorrow, the 17th, he celebrates his birthday. So those are the Kiwanians who are special birthday greetings to them and anniversary greetings to Lowell and his wife when it comes around. I take this opportunity now because we have a lot of fellow Kiwanians on the meeting. Is there any Kiwanian celebrating a birthday or anniversary, graduation, or any special occasion that they'd like to share? Now is an opportune time to raise it.
Well, we have dual member LG Desmond.
Ah, yes, yesterday. Celebrating his birthday. I hope LG doesn't mind. He was celebrating 69 years birthday. So give God thanks and grace for another year on this earth, and wishing him many, many more from Kiwanis School of Kingston and by extension, everybody who is here on the meeting. Is there anybody else who's celebrating a birthday, anniversary, special occasion? If not, let's transition now into our next item, which is Kiwanis education, before we get into our guest speaker and our main event. I think LG Desmond, if he has recovered from his birthday celebrations, he's down for Kiwanis education. LG, are you online?
No, he's not present, and I'll just do something very quickly.
Okay, thanks. I appreciate it. Go ahead.
I just took out my book on leadership guide, and I saw interesting section to do with club status. The term "in good standing." Many of us are familiar with this, but there are a few that may not know. To be a club in good standing, a Kiwanis club must comply with the essential actions of a Kiwanis club as defined by the Kiwanis International Board. A, comply with all the provisions of the bylaws and policies and procedures of Kiwanis International, its district, and its federation, if any. B, comply with the current standard form for club bylaws modified as approved by the International Board of Trustees. C, implement community service projects, including those that support young children, priority 1. B, sponsor or support a Kiwanis Kids program, Builders Club, Key Club, CKI Club, Action Club, or Kiwanis Junior Club where possible. E, maintain an active membership of not less than 15, set a goal of a net increase of at least 2 members per year, and stage pre-induction orientation, formal induction of new members. F, pay dues, subscription, and other obligations to Kiwanis International, its district and its federation, if any, within 90 days after such amounts are due. G, meet at least twice monthly with a web-managed, informative, and fun club meeting which contains informative program and follows a timed agenda. H, schedule board meetings at least once a month. I, monies received from fundraising projects in which the club participates, or from members, or from the service activities sponsored by the club, shall be segregated from administrative funds and shall be used only for charitable, educational, religious, and ancillary activities. J, complete annual club organization, including the election, reporting of officers, and appointment of committees. K, have club officers participate in club leadership education. L, participate in district and division activities, including fulfillment of its club delegate obligation to district convention. And finally, file all reports as required by Kiwanis International and by the district and federation, if any. I trust that we found that interesting. Over to you, President.
We did find it interesting. Thank you, DLG. Willie, that was very insightful on Kiwanis education. So, ladies and gentlemen, we have now come to the main event. I'm going to pass over to DP Stuart Spencer to give you an introduction to our guest speaker and the topic this evening. DP Stuart, I think I saw you earlier.
Yes, I'm here.
Okay, go ahead. It's all yours.
Thank you, P. Stephen. Fellow Kiwanis and guests, as you may have heard earlier, this evening is a recorded presentation that was done in February 2022. But I had been getting requests on this topic. In fact, it was the president who some weeks ago said, why don't you do a topic on wills and so on? And I said, we did that. But it just so happens that, and I don't mind sharing this, that the program that I had planned for today, I had a late change. And so I thought this was a good time to present this topic again. Now I'd like to also add something. Among our guests and among our members present is DP Arturo Stewart, who did the introduction of Abiola in February 2022. So I'm going to start the recording from his introduction. And I also want to add that, in laws, some things change, over time. So he is going to be in a position, she was working with his firm at the time. So he's going to be able to point out any changes that have taken place since this presentation. So we're well prepared for you. So what we're going to do is we're going to play it from the introduction and then take it to the end of our presentation. And then I'll ask DP Arturo to comment on anything that he's aware of that has changed in terms of the laws. And then we'll open up for a Q&A, but a local Q&A, and we'll ask DP Arturo to basically respond in that particular case. So let's start with the I've got to share my screen and so just give me a second.
Muted.
Not hearing anything.
It hasn't started yet. You're now looking at the screen. So are you hearing me now?
Yes.
Okay, so I'm now going to start the presentation with the introduction by DP Arturo.
Paul and President Audrey, distinguished Kiwanians and guests, it's my pleasure this evening to introduce the guest speaker, Mrs. Abiola Pereira Bertram. Abiola, who is regularly called Abby, attended Campion College and was admitted to practice in Jamaica in November 2003 after graduating from the University of the West Indies, having first obtained a Bachelor of Science degree in accounting and management, and thereafter a Bachelor of Laws degrees with honors. And she continued to graduate from the Norman Manley Law School, where she obtained the legal education certificate. Abby joined the firm in 2003 and was appointed a partner in 2009. She began her practice in the field of probate and administration of estates, estate planning and preparation of will and testamentary documents. Although she continues in that field, her practice has grown to include conveyancing of real estate, including the sale and purchase of property and leases of residential and commercial property. Abiola has a significant labor law and industrial relations practice involving negotiations between trade unions and employers. She also has a growing corporate and commercial law practice, which includes incorporation of companies, including charitable organizations, and the handling of tax exemption applications on their behalf. Abiola is a member of the Jamaican Bar Association, and additionally, she has had the privilege of representing Jamaica in regional and international volleyball competitions as a member of the national women's senior team between 1998 and 2002. Fellow Kiwanians and guests, I have pleasure in passing over to Abiola Pereira Bertram, who will present on as guest speaker.
Thank you, Arturo. Good evening, President Paul, President Audrey, Kiwanians, guests. It is certainly a pleasure to be here this evening with you. It is as if I'm coming home. Having been in Key Club during my high school life and Surf K in my university life, it certainly feels like I am, you know, among family. So I thank you for having me tonight, and I thank you for your enthusiasm as it relates to estate planning and a little beyond estate planning, but why a will may not be enough. So without further ado, I'm going to ask that I can be enabled to share my screen.
You are made a co-host.
I'm getting a different message.
Okay.
You can share. You can share.
No, I'm able. Now I'm able. Thank you. All right, so there we are. I'm just going to work out the logistics of this.
I never remember that I was there.
All right, so thank you.
Next one.
Thank you again. Let us start this slideshow. So why a will may not be enough? So the question is then, what is an estate? We come to talk about estate planning. What is an estate? Sometimes people think of an estate as something in the UK with unending meadows, unending fields, very large parcels of land, but really it's much more than that. It is not only confined to large property, large real estate, but really when we come to speak about an estate, and your estate in particular, I want you to consider what you own, your assets. Easily identifiable. If you have a car, you own a house, you have money or cash, jewelry, collections. Some people have stamp collections or music collections, art collections that are quite valuable, intellectual property, investments, both paper investments and online investments, NFTs, non-fungible tokens, cryptocurrency, and things like goodwill. So you want to take a stock of what it is that you do have, what do you own? And while you do that, you want to consider also the things that you owe, your liabilities, your debts. And when we speak about that, we speak about things like a mortgage or student loan or car loans or contract debt, whatever you may owe to someone else. You may say, well, I don't have any assets, but consider even your NHT contribution refunds could someday reach your pocket as an asset. So the question then is, well, now that I recognize that I have an estate, why plan? So planning gives you some form of control. I'm sure you would agree. When there's a plan in place, we know what is to happen. We know who is to benefit from something. We know who is to act, who is to do something, perhaps on your behalf when we're speaking about estates. And when we speak about estates in this context, I want you to join me in thinking of an estate, not just what happens after death, but also your affairs generally, even now. So you want to consider what will happen to those affairs, both now and at a time to come, perhaps when you're no longer here. And then we want to talk about the when. In planning, what planning really does, it assists you in avoiding what we call the probate process. Now, the probate process involves a will, or if there's no will, an application to the court in relation to an intestacy. And we will come to that in a minute. But this application to the court, whether there is a will or not, is timely. It is time consuming, I should say. It is costly. And what I would hasten to say is that a will before the court becomes a public document. So the will is proved, the court pronounces for the validity of a will, and after that will has been recorded at the court, it then becomes a matter of public record. What that means is that anyone can access the content of your will once it has been admitted to probate by the court. And when we say admitted to probate, we simply mean that the court has pronounced that the will is in fact valid, and then the executors are able to continue the process of administration of your estate. So again, we come to considering planning. Well, planning allows you to protect those who may be vulnerable, like minor beneficiaries or adults who have challenges. You can put special arrangements in place to provide for special categories of beneficiaries. Arrangements including guardianship, for example. So if you have children under the age of 18, minors, you would want to consider, well, what would happen if I or their other parent is not available to take care of them? Who would I want to appoint? If there are persons who are going through a divorce and who are going through sensitive times, whether through addiction or they have a challenge securing funds or keeping funds, retaining funds, planning your estate can allow you to make provision for persons, even though you may not be putting everything in their hands at the same time. It's easy to see that planning also helps you to avoid conflicts because, as they say in Jamaica land we love, if you want to see a fight, just look for the dead left and you will find it. And unfortunately, it is something that we see in practice. Planning also allows you to protect your assets. You can maybe put an asset aside for a particular beneficiary, and it allows you to isolate assets. And we will come to the different vehicles or tools that we can use to protect your assets. And then, as we spoke about a little earlier, when we plan, we can minimize costs and fees, and we can also, in some form, ensure that assets are available for beneficiaries and not available for creditors if we owe. So listen to this one. We're going to wake it up. So these are all your assets coming in. What can you do? So you would have seen there my idea of what a fit estate might look like. All the different tools that we can use, what we call a legal toolkit to ensure that all of the various options available to you can be utilized. So let us start with one of them, and that would be life insurance. And I know that, as I believe it was LG Rosie had said, this is not a topic that people always enjoy speaking about. It's a touchy topic. Oftentimes people, specifically in Jamaica, are very private about what they do. They don't want anybody to know, but it does beg for some arrangement and planning of your affairs. So I'm happy that you're taking the time to take this in. So let us start with life insurance. And life insurance, as you would know, would be a contract where the policyholder takes out insurance and the insurer promises to pay on the death of the insured person a certain sum of money. And it's simple. To claim on this policy, you simply produce the proof of death, which would be their death certificate. In many cases, parties use it to meet the funeral arrangements of the deceased. And now we have family indemnity plans being offered more commonly across the country here in Jamaica. And so there are ways in which you can protect for certain beneficiaries and you can protect for final expenses. I make a point here to say, take care when you're taking out life insurance policies. We have seen that rather than naming a beneficiary on the life insurance policy, the party taking out the policy has instead put estate as the beneficiary. And what that does is certainly put the funds right back into your estate. So it will not go to a named beneficiary, and putting it back in your estate really means that your loved ones will have to then apply to the court, whether for probate or administration. And when we speak about probate, we speak about proving a will. And when we speak about administration, loosely speaking, we speak about the court approving an administrator to go ahead and stand in the shoes of the deceased person to collect in all the assets and then distribute them to the beneficiaries once all the creditors have been paid. So if the idea of life insurance is to avoid probate, avoid going to the court, then we want to ensure that we do not name an estate or the estate as the beneficiary, but we put the name of the person or persons we wish to benefit. All right. Another way that we can structure our affairs is a power of attorney. And now this is a document, it's a written document, as is the life insurance policy, that appoints someone to act in your place. Of course, now this person is going to be one in whom you have the utmost confidence. And when we say someone who acts in your place, oftentimes the power allows, this is the power of attorney, it allows the person who you appoint to do all the things that you would have been able to do. You can see and appreciate immediately that it could be very far-reaching. Now, in order to prepare a power of attorney, you only need to be 18 years or over and of sound mind and judgment. So that is one of the elements to create a power of attorney. It can be a simple document and it can become more complicated. It can be a tailor-made document just for you to cover particular issues, like, for example, maybe the sale of shares or the administration of someone's estate, or it could cover specifically bank accounts, or you could have a very broad power that appoints we call it the donee, appoint someone to act on your behalf in every single respect as you could have acted. A good point to note is that powers of attorney can be revoked. And that another point to note is that they are effective while you are alive, and at the time of your passing, they're nullified. Now, you want to consider a power of attorney to take care of instances where you are either incapable or unavailable. Now, for example, if you're overseas for an extended period, like in the pandemic, If you were overseas and you had business here in Jamaica and you wanted assistance, a power of attorney is a document that a person in Jamaica could have presented on your behalf, whether it be at the bank, whether it be to transact business at the National Land Agency in relation to registered land, or to transact shares, to do what you might have done had you been here. A power of attorney is a very useful tool. But I would say the timing is critical. You don't want to start looking about a power of attorney if you are incapacitated in any way. By incapacitated in this respect, I mean you are not of sound mind, because at that time, the law would not deem that you have sufficient capacity in order to give the power to the parties, and there would be perhaps a feeling of undue influence that would be inferred. So at the time of making a power of attorney, it is important that, yes, you are over 18 years old, but you are also of full mental capacity. So I would encourage you to have a power of attorney in place, to appoint someone who you are satisfied would do what you wish, would do as you wish, as you instruct, because it doesn't mean that you give them all the power. It means that the power of attorney allows them to act as you direct, right? If you're incapacitated, it also allows them to act as you would. And so, again, it is a very far-reaching document. And the good thing about it is that it can be tailor-made to your circumstances. So we move on a little bit now. We move on to what has been identified as a living will. And loosely speaking, these are your medical wishes. And this is a concept that we are seeing coming in from North America in particular. And what it is a written statement detailing your desires for future medical treatment in circumstances where you are not able to say what you would want to happen. For example, let us use the pandemic again. We have an issue where the vaccine is to be administered. What would your wishes be on that? Does anyone even know? Or if there is palliative care that is required, does anyone know what your wishes are? And so a living will allows you to state long in advance that these are my wishes. It's a declaration that can speak to both your physician, your doctor, and your family to say, in the event that this happens, this is what I want to be done. And so more and more, I have clients coming now to ask me to prepare living wills. So that is another tool in the bag, the Get Fit bag for the estate. Another tool that we can use is in relation to how we hold property. Now, property can, and remember now, all of this is with a view to minimizing time and costs. And so when you hold property jointly, let's take real estate, for example. On the death of a joint tenant, let's say there are two of you who own property together. On the death of a joint tenant, the surviving holder is the owner of the entire property. So in this case, there is no probate. We're not going to the court for an application to either approve of an executor or appoint an administrator to take care of your estate. In fact, the property does not fall to your estate. The person on title with you at the time of your passing will then enjoy being the only person on title having noted your death. It does minimize the transfer tax that is due on death, and of course avoids the application to court. A similar benefit can be enjoyed when we come to speak about joint bank accounts. Spouses use it often, children and parents use it often. And this is in accordance with the bank's mandate now, with the mandate meaning the account opening documentation that you sign up when you sign up for the bank. And usually that account opening information indicates who benefits from the funds in their account. And provided it is a joint benefit for both or the multiple parties who are the account holders, then the survivor or survivors will then be the beneficiaries of what remains in the account at the time of your death. It is simple to access. You would simply produce the death certificate, or the survivor would produce the death certificate, and the banks would simply note that the account holder is now deceased. No transfer taxes payable, no application to court is required. Again, minimizing costs, minimizing time. And similarly, if you have joint shareholdings, if you have shares on a company that's listed on the stock exchange or any other, one way of arranging your affairs to minimize all of the possible effects of an estate, a matter going to an estate, is to have joint shareholdings in companies. Okay, another tool, trusts. Little used in Jamaica, but much more common elsewhere. I suspect it is on account of ensuring that the trust is funded. So let us speak a little about what a trust is. A trust is where one person is bound to deal with property transferred to him in a particular way and for the benefit of a specified person. So, for example, you could have a trust given to someone to say, I'm going to give you $50,000, or it is written, $50,000 will go to George for purposes that I've identified to him. Or $50,000 will go to George for him to take care of John for the next 10 years or so. A trust document, it is a document. Again, we're dealing with written documents. A trust is a very flexible tool. It allows you to appoint someone to control property for the benefit of another. It allows you to say what property and who is to benefit. And it also allows you to appoint a trustee to control that property. Again, we come to the importance of trust and integrity in who you would consider to appoint as a trustee, because this is the person who will have control of whatever asset it is to be able to have the benefit pass on to the named or unnamed beneficiary. Trusts are widely used. In family situations, you would hear of a property being in trust for generations. And so what that does, it provides successive generations with access to the property without the property being at a risk of being sold or transferred out of the family. It also protects minors, where a trust could be set up, for example, to give a minor a certain payment every year or every month. Again, you can configure a trust if it is that you really think that your son or even your spouse could be a spendthrift. Then you could set up a trust to say, well, every month this amount is due to you, or that the property that is located at 2 Arden Road is for my child, but it is to be held in trust until they're a particular age. So a trust can also allow secretly for dependents. So you may say to your friend, I'm putting down $500,000 and it is to be applied as you know. And it would have been for that friend now to rely on the previous discussions that you would have had to then go ahead and share those funds or distribute those funds to the beneficiary that you would have identified. But the beauty about a trust, when I mention secret, there is a concept of a secret trust under the law. And in times gone by, it was commonly used in the UK. and I suppose elsewhere, where there were children that the spouse or partner did not know about. For that friend now to rely on the previous discussions that you would have had to then go ahead and share those funds or distribute those funds to the beneficiary that you would have identified. But the beauty about a trust, when I mention secret, there is a concept of a secret trust under the law. And in times gone by, it was commonly used in the UK, and I suppose elsewhere, where there were children that the spouse or partner did not know about, or someone else who the person making provision did not want the public to know. So the idea of a trust is that it is very flexible, and you can now devise how you want it to look, who benefits. And the beauty about a trust is that a trust can be set up in your lifetime. So today, you could get up and do a trust in favor of anyone, and that would take effect now. Whereas when we come to speaking about wills, we know that wills only take effect on death. Okay, so we come to speak about wills. So a will is a written document. We have laws that govern wills in a very strict sense, how it is to be made. We're not at a stage where you can broadcast your wishes over Instagram or Facebook and think that that has made your will. A will is required to be made in writing. And we will touch on a will because a will can be a simple document that you can do to protect your affairs, your estate, and it says what you want. A will can say what you want, and also that flexibility then is one of the keys in making a will. We want to, however, realize that that flexibility has a few issues that will arise that will cause that flexibility to be tempered. And I say that because there is a provision in our laws that allows someone to say, you have not made provision for me under your will. And I am a person who you have provided for during your lifetime. And I therefore am to enjoy that same protection and care on your passing. So the general rule is that you have what we call unfettered testamentary freedom, which really means it's your will, it's your assets, it's your estate. You can do what you wish, give it to whom you want, don't give it to whom you want, etc. But there is a concern that when this act is looked at, those who are dependent on you can make a claim to the courts to say, well, not so fast. No provision was made for me in John Brown's will, and I would like the court to declare that I have an interest in the estate. And oftentimes applications are made by, as I said, persons under 18, a spouse or a parent who was maintained by the deceased prior to death, or where there was a court order in place. And when this kind of application is made to the court can award payments or transfer of property. So it is very wide in terms of the discretion that the court brings to bear. So my response to that would be, if we move to making a will and you have decided that you don't want to leave a certain person you don't wish to name as a beneficiary, then my advice to you would be, explain why in your will. And I say explain why in your will because then the court has something to refer to when it wants to understand what your considerations were. What if it is that there is a joint account held by you and this person and you've already made adequate provision, for example. So there's no need to make provision in the will. So you want to explain, if it is that your circumstances fall into this scenario, why it is that you may have left out an individual as a beneficiary, or even if you're not leaving them out, just to be aware that this could be a claim on your estate. I seem to have been missing a slide, just the introduction into relation to what is a will. So I'm trying to cover that as we move along. So a will, this is kind of what it does in a nutshell. When you make a will, and a will could be, it is certainly written on any kind of paper. It could be in hand, it could be typed, it could be printed, computer printed. When I say typed, I mean typewriter. That will suffice. What is important is that a will, when you make it, it revokes any earlier will that you would have made. So no two wills stand on both at the same time. Making a will revokes or nullifies an earlier will. Now we move then to some other content in the will. A will, properly drafted, will appoint an executor. An executor is the person who will take your shoes on your passing, and that is the time at which the executor's authority arises, not before your passing, but on your passing. That is when the executor's role begins. You may also wish to appoint a trustee. Now, we spoke about trust earlier, and we spoke about someone being appointed to control property for the benefit of another. We can do that in our lifetime, or we can do that also in our will. So you want to think about those persons, and you also want to think about, if I have minor children, who is it that I could leave? Whose care can I leave them in? Who will I be confident that will be raising them in the way that I would want? So there are three, perhaps, roles that you want to think about. Maybe one person suits them all. Maybe it's three individual people that we're thinking about. But you have the opportunity to name the persons, ideally with their agreement. Certainly guardianship, you want that person to agree that they will be taking care of your children. Executors and trustees too, you want them to at least be aware that this is what you're planning to do and have their consent that they're agreeable to acting on your behalf in this way. Now, other than identifying what you have and who you want it to go to, a will can also determine something like how you want your body to be disposed of, whether you want a church service, and the like. So a will can speak to that. If that is important to you, it can be included in your will. Now we move to how we give what we have remaining at the time of our death. And yes, you can have what we call specific gifts. I give to John Brown my trophy collection. I give all my furniture. I give my car. But other than what you specifically give, we refer to a clause that we advise that you have in the will as a residuary clause. And in that residuary clause, what you're going to say there is that I give everything, or everything that I have not named, I give to so-and-so, and we regard them as your residuary beneficiary. I want to say there that you want to pay special attention to who you would name as this residuary beneficiary, because oftentimes the residuary beneficiary can have a windfall because you're not quite aware of what might be in the residuary clause at the time you pass. And importantly, you want to sign your will. You must sign a will. And we say that 2 witnesses must be present, or the Wills Act really requires that 2 witnesses are present who must see you sign and sign in each other's presence as well. And so there's some technicalities in relation to making a will. I'll go through quickly. If you make any alterations, then those must be properly signed, and you should initial if there are any changes. Importantly, if you're getting a gift under the will, you really should not witness, because if you do, it will invalidate your gift. I want to just make a couple points quickly. If you're making a will, or if you, let us say you got married yesterday and you made a will last year and you got married yesterday, today it would mean that your will is null and void, because marriage under our laws nullifies a will. Importantly though, not divorce. So we want to make the point that when you contemplate marriage, you want to make new provision. And if you go through a divorce and you feel that you should adjust your estate differently, then you really want to make a new will. And the beauty about wills is that you can make a new will every single day if you wish. There's nothing binding you to a will that you would have made last year or the year before. Testamentary freedom is the order of the day when it comes to making wills, and that allows you to make a will as you're choosing and with the considerations that you have in mind. A will be invalid if it's improperly executed, as we said, and certainly if I intended to give you everything on my passing and one day you upset me to unbearable ends and I decided to tear up that will, that is a revocation of the will. And so nothing in that will would be effective. There would be no provision effective to pass property. And we just come quickly now to what happens when you have no will. The law sets out a table of distribution, who will get what, and I'll just go quickly through it. But in relation to an estate, this is now on your passing, where there is no probate, no executor, then the person who is to be appointed by the court has to actually wait until the court has issued a grant of administration before they can act in the matter. And of course, you can see that that could create challenges for those who are left in limbo until the court process is complete. Again, there's some bureaucracy when we come to dealing with minor children. The Administrator General actually has a duty to intervene and obtain a grant and there is an estate and there are any beneficiaries in that estate that are under 18. So this is all more reason for you to go ahead and make that will, because I'm certain you would rather have your loved one in charge or your trusted ones in charge of your estate rather than a government appointed official. And so just quickly, this is how an estate is shared under the law. And we're going to personal chattels, not that in relation to business, but personal chattels, $10,000 or 10% of the net value of the estate, whichever is greater, plus interest and some more, as in this schedule here. I won't spend too much time on it, but just to say that the spouse is the first qualifying person, and then children, brothers and sisters, parents, grandparents, uncles, and if there is none, I want you to know that your property may really end up going to the government. Bona vacanter, we say. So make a will. It's less time consuming. It identifies the assets and you know clearly who will be getting what. It helps to prevent false claims, because then you don't have people coming forward and claiming they're your children, claiming they're your spouse, claiming they're your cousins. When you have a will, there's clear entitlement because the will outlines it. It prevents family squabbles as well. You stay out of the Administrator General's office, and certainly wills and any tools that we've covered here today bring peace of mind to you as the person, because then you know that what you've put in place will fairly take care of what your plan is for your estate. Quickly speaking, there are some tax exemptions to be gained when you structure your affairs accordingly. Stamp duty is minimized, death duties are minimized. So in summary, there is an arsenal of tools for estate planning. The easiest one that you may be able to do on your own is to go ahead and make a will. If you think you need legal support, please go ahead and get it. You want to consider things like appointing a guardian for a minor if you want a trust in your will. You could also consider a trust, a living trust, as they say, or the power of attorney, or the living will. Remember now that you want to review your will frequently. or as the circumstances of life demand. So if you are acquiring new property, you have the birth of children or grandchildren, certainly on marriage or the death of a beneficiary. You want to look at your insurance policies, ensure that they're sufficient to meet the needs that you hadn't expected, ensure that someone is named. You want to add the intended beneficiary to your bank account as a joint tenant. And where practical, you want to hold assets as joint tenants. And so that kind of, in a nutshell, is what we have in the arsenal of all the legal toolkit to deal with estate planning, not just your will, but much more. So thank you so much for paying attention, and I'd be happy to answer a few questions.
Well, fellow Kiwanis and guests, that was the complete presentation. There were some questions and answers, but I'm not sure if I'm going to play those because there may be some from this audience. But what I want to do next is invite DP Arturo to update us on any changes that may have occurred in the laws affecting wills and estates, so that we don't leave with an incorrect impression based on something that was presented 2.5 years ago. So can I call on you, DP Arturo? Are you ready?
Yes, you can take down the document off the screen.
Okay.
So that I can see. Good evening, fellow Kiwanians. I am sitting in for Mrs. Bertram, who you may not have noticed, but she has since moved on to join the University of the West Indies as their legal officer. So I am here batting solely from one side of the wicket. I don't have another runner on the other side of the wicket. The first thing before questions are being asked, I think I need to inform everybody that there have been substantial new legislation which touches and concerns the whole matters of trusts and companies. Now, Abiola pointed out that you could create trusts while you're living by appointing trustees to deal with certain property and transfer that property to those trustees. One of the ways that people also create trusts is by incorporating trust companies, which have perpetual existence, and transferring the property to the trust company. This is something that used to be done once by banks, but the banks have gotten out of that business. So some individuals set up their own trusts and then appoint directors for the trust companies. In a number of cases, some politicians I know are required to place their property in trust where they hold certain positions, such as members of the government, not just necessarily members of parliament, but cabinet members of the government, and certain other positions like the governor of the Bank of Jamaica, and those sort of positions that have, you don't want to have conflicts of interest. Now, what has taken place since then is that in order to move Jamaica off the gray list when it came into the requirements put down by the Organization for Economic Cooperation and Development, where certain countries were put on a gray list because they were deemed not to have sufficient legislation and eliminate or maybe just reduce money laundering. So you have two issues in relation to money laundering. You have money laundering by criminal ill-gotten gains, and you also had concerns about terrorism. And the whole thing got great attention upon the invasion of Russia. Russia invaded Ukraine. So a raft of legislation floated out of the United States and Britain, banning Russia from conducting business because of the political situation with the war in certainly North Korea was banned for many years from conducting business to keep them out of the general world economic picture. However, as a result of those sanctions, it became acutely aware that certainly the Russians had a lot of property for which they were not identified because they acted through trust companies set up primarily in British dependencies, like the Cayman Islands, the British Virgin Islands, Channel Islands, the Jersey Islands, et al. We being in the Caribbean got lumped
You're frozen, Arturo, it seems like. Let's hope he'll soon be reconnected.
into that.
Arturo, you were frozen a while ago. So we missed about a minute. Are you hearing me?
I don't know what happened there.
Okay, you're frozen for about a minute. So
okay,
if
I
you
was
could
frozen
just...
for about a minute. Okay.
All right.
No, I was speaking about the money laundering regulations that were now being made applicable because of the not just the Russian invasion, but of the Ukraine, but also the concerns about the moving of drug money through the island. And the latest legislation that came in relation to that was the Trust and Corporate Services Providers Act, which essentially sought to give additional regulation to lawyers and accountants, corporate secretaries, and anybody who would be providing trust services or doing corporate work, which required them to be licensed. There was a huge debate that went on after it was passed, because at the time when it was passed, what appeared particularly onerous to the professionals was the annual fee which had to be paid. I don't think the problem was so much with the registration, but the annual fee seemed somewhat exorbitant. So unless you had a high volume of trust and corporate services work, the large proportion of the legal profession and chartered accountants decided that they would take that off their portfolio of doing work. So lawyers who had exposure by working in the British Virgin Islands continued to do such work and registered with the Financial Services Commission, obtaining licenses to provide trust and corporate services. Services Providers Act suggested that executors for wills would also have to register. Now, the fact of the matter is, as you heard at the beginning of the meeting, was that there are two things that are certain in life: is death and taxes. So the point was made that since everyone will die at some stage, and in order to not leave their estates in chaos, it was recommended that they write a will, which would of course appoint executors, and executors, more often than not, whether it is stated or not stated, become trustees for those who they are distributing the estate to. So the view was expressed that lawyers who are just dealing with writing wills will not be prohibited from doing so, and would not therefore, in a sense, be creating trusts under those wills. However, if they held themselves out as providing trust and corporate services in the manner in which any of you have been to the Cayman Islands or the British Virgin Islands and entered a lawyer's office, the first thing you notice that there are no human clients inside the offices. There are several plaques that cover the wall, like wallpaper, of companies creating trusts for individuals that don't live in that country. And those law firms make an enormous amount of money by filing returns and acting as trustees for those companies by being directors of those companies. Now, what we have done locally is we have said that in addition to the Trust and Corporate Services Providers Act, any company that has, any company at all, public or private, registered with the company's registry in Jamaica, you must disclose who is the beneficial owner of the shareholding. So whoever is named as a shareholder must file a document to indicate whether the named shareholder is also the beneficial owner or they are holding those shares in trust for someone else. So it has, in a sense, narrowed down the, what would I say, big money, whether legal or gray, secretly putting money in corporate bodies in which the beneficial owners are not disclosed. So under normal money laundering provisions, people will continue to do their business, but they have to disclose source of funds and where they indicate that they own property, that they are indeed the beneficial owners. So those are the changes that have been made, which will affect the concepts of creation of trusts. Apart from those changes, everything else that Mrs. Bertram had stated in her presentation holds true. So I will stop at that and then invite questions.
Okay. Thank you, DP Arturo. Let me defer to President PE Stephen, who may want to seek an extension of time, as we should do, and then we'll open the floor for any questions based on what was presented by Mrs. Bertram or what DP Arturo has had to add. Stephen, could you go ahead?
Thank you, DP Stu. We did start the meeting late, but I think that we can extend questions for just another 5 to 7 minutes, and then we will have to wind up. So I'll take the opportunity to ask Kiwanis Club of Kingston members for motion to extend the meeting by 10 minutes.
I'll move it. Okay, I second.
Was that DP Trevor?
Yes, and I second.
Thank you very much, gentlemen. Proceed.
Okay. The floor is now open for questions. Let me just say this to you, Arturo. The whole, you said that executors have to know, there's a little bit more, they have to know, meet some other criteria. Has that resulted in people say, I don't want to be an executor? How would that affect us in the Jamaican context?
Well,
or have you noticed if that is happening?
Well, what I would say, even before the act came into being, many years, just about all the banks believed testators of trying to decide who they would appoint as an executor for their estate, because the trust companies would readily act as executors of estates. The trust companies did charge a substantial fee for acting as such. In any event, all executors, whether you are a trust company or individual, are entitled to a fee of 6% of the gross value of the estate. But it's not each executor, it's the executors of that estate. So that if there are two executors, it's split 3% each, but the total would come up to 6%. What has happened is that the trust companies could charge additionally for the work they were doing. And they seem to have come to the view that it was tedious work. They would lend out monies of estates, for instance, on mortgages and that sort of thing. And they have gradually, one by one, closed down their trust companies and have ceased to do that sort of work. So it has then fallen back now on the individuals finding trusty friends, trusty lawyers, trusty accountants, and relatives to act as executors. So the executor business now has become quite informal and not formalized as it was some 2 decades ago.
Okay,
So
I have a question. Thank you. I have a question that I see in the chat. Let me read it. I haven't actually read it first. I'm just reading it for the first time. It says, if you have property in another country, should a separate will be prepared in that jurisdiction, or can you prepare a comprehensive will in Jamaica that covers all properties across borders? Interesting question. What do you say to that, Arturo?
Yeah. Because of the differing laws in the different countries, it is recommended that you do a separate will in the particular country, because what occurs if you have one will dealing with your property worldwide, it may affect both countries, especially if they don't have double taxation treaties in terms of the estate duty. We have in Jamaica here transfer tax, and the transfer tax has been substantially reduced. So I personally and some lawyers have been discouraging people from transferring their property to their, as real estate in particular, to their beneficiaries before the time of their passing, because that used to be a common way of reducing the taxation liability upon death. And so that people used to transfer their property to their children. And that sometimes produced some very strange results, because if they live much longer or so forth and they became incapacitated, they could find that the home they lived in, they were being dispossessed of it, and the children ran off and used it to raise monies and create other problems. But there is no need now to rush ahead of the terminal situation, because the transfer tax on death has been reduced to a small amount of 1.5%. You're coming all the way down from 15% to 1.5%. So it's a I don't even want to call it a fraction. It is really a huge difference. And that came about to sort of free up a lot of real estate values in the country, where people were sitting on large values but couldn't get the cash out of it because they had no money to pay the transfer tax. So unless somebody was coming to purchase it or buy it, or they were going to conduct business with it, they were not able to utilize that capital value until some event like that. But now that the transfer tax is small, they don't need to rush to transfer it before they die, and it can be utilized, right? And the beneficiaries are going to have to pay a small 1.5%, which can easily be covered by adequate life insurance protection to deal with that.
Okay, thank you for that. Okay, I don't see any hands up, and I don't see any more questions in the chat. So I'm going to take it that you know, everything is pretty clear to everyone, and because we're running a bit late because we started late, I think this is a good time for me. Now, we didn't designate anybody to do a thank you because Mrs. Bertram was not going to be here, but let me undertake to say a thank you to her in her, you know, because she has moved on from Grant Stewart and Phillips. But I'd also like to say a big thank you to DP Arturo, who, when I shared with him what my plans were, it struck me, you know, that, hey, since I'm not gonna have her present, you know, that it would be nice if he was present to answer any questions that may come up. And then he told me about, you know, there were some changes in the laws that are relevant. So I want to thank you again, Arturo. You know, it has, at short notice, you stepped in and you filled that little vacuum. And so our audience has been totally illuminated in terms of what is and what is not. And for that, thank you very much for being a part of this presentation. P. Stephen, back to you.
Thank you, DP Stu, and I would also like to endorse the gratitude to DP Arturo, fellow counsel, always helpful and giving some legal guidance. People, and please take heed to the presentation by Mrs. Bertram, as well as the further guidance from DP Arturo. Your future and your family's future is very important, so you should always keep that in mind and plan accordingly.
May I just add one little quick thing? I'd like to invite you know, persons present, if they could subscribe to our channel, our YouTube channel, which we have called a KCOK YouTube channel. And you will be able to look back at any of our presentations that we have done in the past. I mean, we didn't quite get it going just at the time of COVID, but from pretty much that period on, we have pretty much most of our presentations. But it helps if you subscribe. because I thought, I'm not making a little pitch to you guys who, that we'd like you to do that as well.
Yeah.
Okay, back to you.
Yes, anybody's on YouTube, you know the usual script. Make sure you like, share, and subscribe. The subscribe button is right up in the right-hand corner. Click like, share, subscribe. Thanks, everybody. Appreciate it.
Okay.
All right. On that note, we're going to hand over. Is Chairman Zuri on the call? He's our Sergeant at Arms. Or is there a Sarge for 23 CSO? We reached to the Sergeant at Arms part of our program.
Oh, yes.
I'm looking at all the members. Oh,
yes.
You do? Go ahead.
Yes, we just do
go
a
ahead.
blanket Sarge for
Sure, go ahead.
For about $300 for the members of 23 CSO on the platform at this time. Thanks.
Okay. Good evening, everyone.
Good evening, Chairman Zuri. So your CSOs,
my members are not so lucky. We're not a blanket. We're not doing a blanket.
Your signal is stretching out.
His use
your signal is, you're not coming in very clearly, Zuri. You're not coming in very clearly. I don't know what choices you have, but
Desmond is trying to talk. I'm not hearing.
Okay, much better. Go ahead, Zuri. We're hearing you much clearer now. Go ahead.
Oh, you weren't hearing me?
No, your signal was staggered. So we're hearing you loud and clear now. Proceed.
Oh, okay. So the first charge was for DP Earl for using 69 to get out of a traffic ticket. And then LG Desmond also $300 for notifying us of it. And DLG Willie, $300 for your 4 messages of the same thing, same meeting invite. And for the Canadian Bake Sun Posse, so DP Chris and Kiwani and Carlo Mason, $300 each. And the PD Stephen, I could not leave you out for forgetting to tell them to click the notification bell, another $300. Those are the charges.
All right. Thank you, Sarge, Chairman Zuri. That's a good one. Well noted, and everybody make sure you make your contribution to the club's coffers as part of the activities. We're winding up the meeting now, and we now move into notices and announcements. I'll ask, first of all, DLG William Reeson if there are any announcements from Kiwanis Club of Kingston, and then President Dr. Eurydice also announced notices and announcements, as well as interclub activities for 23 CSO. Go ahead, you have the microphone, DLG Willie.
Thank you. Thank you, President Designate Stephen. First notice, we'll be having a fundraising meeting at my house on Thursday. And this is basically our main focus will be on looking at where we are regarding the benefit performance to the National Dance Theatre Company being held on Saturday, February 27th at 8 p.m. By now, all our members are aware of our fundraiser, and I'm urging or imploring all members to buy at least 2 tickets, because we have bought out the house, and with the participation of other clubs, Kiwanis Club, both in Division 23 Central and 23 East, we have made a good indent on those numbers. So thank you to the participating clubs that may be present, but to our members, please come out on Saturday, 27th of July for our Barbie, for the National Dance Theatre Company benefit performance. President and myself saw our review last week, Thursday. We were very impressed. And I'm sure it's going to be an evening, lovely evening. 2 other notices. We have invitation to remind you now, Kiwanis Club of New Kingston, Seafood Friday 2, Police Officers Club, this coming Friday. from 10 a.m. to 4 p.m. And then there will be an after work line from 4 to 7. And the other announcement or invitation we have is from the Kiwanis Club of West St. Andrew, and they'll be having an Emancipendence Party at 9 Norbury Drive, Norbrook, on August 3 from 8 to 2 a.m. Insofar as are the clubbing opportunities, I will circulate those in the morning in the interest of time. Over to you, President.
Thank you, DLG. Willie, 23 CSO, Prez, do you have any announcements from your side?
Well, just one that our fundraising continues, and it's our craft that we're selling, and it's $1,000 and $2,000 per craft, and this goes toward 2 schools that we're working on: the Shady Grove Basic School and the Weeds Road Basic School. And we've done significant work on them, and we just need to continue to push through and get the schools ready for September. So that's where we're at. And if
did you say, President, did you say what is the cost of the art items? Did you say 1,000?
1,000 for some and 2,000 for the others. So we'll get it out there again. I had advertised when I was there in Jamaica, and I'm just putting the advertisement out there so that when I come again, I'll have people will be aware of our craft and the usefulness of it. So thank you.
You should, and I encourage everybody to support the 23 CSO and their fundraising efforts.
President-designate Stephen, you may instead perhaps ask President-designate Claudine Heaven. She just wanted to add something.
Go ahead, Claudine, you have the floor.
Thank you, PD Stephen. And just a small detail that DLG Willie forgot: the cost for the Emancipendence Party, $2,000 pre-sold tickets, $2,500 at the gate, and it includes a meal. Trust me, it is a party you do not want to miss. August 3rd, it's the holiday weekend. Come out with us and have a great time.
Indeed, and support a worthy cause. Yes. 2 wins in one, rolling one.
There you go. There you go.
People, please take note. Is there any other Kiwanis Club who wants to make an announcement? Now is the time. You have an open platform. No, going once, going twice. Okay, thank you, everyone. We're now going to close off with the thought of the week. I think I saw DP Marcel online. I'll hand over to you, DP Marcel, to share with us.
On board, yes, I am. I'll just go quickly, kind of fit in what we have been listening to. 2 thoughts. And first one, if it costs you your peace, it is too expensive. And the other is, in line with that, the less you respond to negative people, the more peaceful your life will become. Have a good evening, all.
See you on Thursday.
Yes, indeed. Thank you very much for that, DP Marcel. DLG Willie, if there's nothing further, I'm going to terminate the meeting. We're running a little bit late. We thank everybody again for their patience for our late start, and I hope that you found the presentation and the discussion afterwards informative. We again thank you on behalf of both Kiwanis Club of Kingston and 23 CSO for your attendance. And in calling the meeting termination, I'd like to offer a toast to Kiwanis International and to Jamaica land we love. For those of you who have glasses or drinks, cheers, and thank you for your attendance. Good night, everybody. Have a safe
Here.
journey home. And if you're at home, have a pleasant